speak for a while, and then I'll turn it over to you for questions. One thing is, Helen just mentioned that afterwards that I might or might not be available for a while afterwards, but I'm not going to put anything in my own presentation here about mobile home parks or mobile home tenancies. And if there are questions about those, probably I couldn't get too deeply into questions regarding mobile home tenancies. But if some of you do have questions about mobile home tenancies, that would be something that after the session, if you feel like you haven't gotten any good information regarding it, we might be able to use the Public Law Center and the library to look up some information on that. But it's not going to be something that I talk about in the presentation itself. What I'm going to talk about mainly here is residential tenancies, although some of the things that are said would be true of commercial tenancies as well as residential, but then a lot of the things that we'll talk about have to do only with residential and not commercial. And the other thing is I'm going to talk about tenancies in Nevada County and places like Nevada County, which can be very different than talking about some of the tenant-landlord situations in large urban counties where they tend to have local rent control and eviction control ordinances. And Nevada County and the surrounding counties don't have those rent control laws. This is a seminar, as you know, on tenants' rights. So the first question is, where did tenants' rights come from? Where would you find out what the tenants' rights are? And the first place to look regarding a tenant's rights for any particular tenancy would be, of course, to look in the rental agreement, which is also frequently called the lease. That's now the rental agreement or the lease between the landlord and tenant have a lot of provisions saying what the rights of the landlord and what the rights of the tenant are. But just because that's a starting point for where you would find the rights of a particular tenant doesn't mean it's the last word. And the reason for that is that there are a lot of rights that tenants have regardless of whether the rental agreement or lease addresses them. And in fact, there are several tenants' rights that even if the lease or rental agreement directly contradicts the right exists even though the lease says it does not exist. For example, let's say you had a rental agreement where the security deposit in the rental agreement was $1,000, and there was a provision in the rental agreement that said that the security deposit is refundable except for $250 that will be kept by the landlord for things that would come up. And let's say the tenant and the landlord sign that rental agreement. Well, despite the fact that the tenant has signed a provision of the rental agreement that says that some of the deposit is not refundable, the fact is it's still refundable by law regardless of what the rental agreement says, because that's an example of a right that the tenant can't give up, even if the tenant says he or she is giving it up. In other words, the law wouldn't enforce the giving up of it. Now, on the other hand, of course, there are a lot of rental agreements that have provisions that dictate what the rights of the tenant and the rights of the landlord are, and those are enforceable by law because some rights can be given up. For example, no tenant has a right to any particular amount of rent just by imposing it on the landlord, but once you enter into a rental agreement and the landlord and you agree to a certain rent, then of course that is the rent that you've agreed to, and of course the law will enforce that. So what I'm going to do now is so that's just sort of an introduction to the idea that to find out what the rights of a particular tenant are, you look to the interplay between the rental agreement that the landlord and the tenant have made and then the law as it affects that agreement. The law will enforce most of any rental agreement between a tenant and a landlord. So now let's talk about what some of the particular tenants' rights are, just in general that are revealed by the law. Well, let me say one thing about the law just before I get into the particular tenants' rights. Okay, where do tenants' rights that come from law, where exactly do they come from? In other words, where are the legal rights of tenants contained? Well, of course, in a government system like the United States, where you have a federal system, we all know we have federal, state, and local laws. There are federal, state, and local laws that affect tenants' rights, but the majority of laws that affect tenants' rights come from the state. Now, again, if you're in a large urban county like San Francisco or Los Angeles or Alameda County, you may have local rent and eviction control laws. But even in those places, most laws affecting tenants come from the state government. And they're either in the form of statutes, which means they're laws passed by the legislature and signed by the governor, or else they're laws that come from what they call case law, which means when a court of appeals deals with a legal issue and then writes an opinion that gets published in a law book, that becomes what they call case law. So we have a lot of tenants' rights laws that come from the state legislatures and a lot of tenants' rights laws that come from courts of appeals. Okay, let's talk about some particular tenants' rights. They will be sort of in chronological order if you think of a tenancy, somebody coming to rent a place, becoming a tenant, staying there for a while, and at some point leaving for whatever reason. One right that tenants have is a right not to be discriminated against. Both federal and state laws prohibit arbitrary discrimination based on personal characteristics. If the personal characteristic is someone's race, religion, national origin, ethnicity, gender, sexual orientation, marital status, disability, medical condition, age, or the fact that there are children in the household, if a landlord were to take negative action against a prospective tenant or a tenant in residence, and it was due to any of those characteristics of the tenant, it would be against the law. On the other hand, if the negative action that the landlord takes against a tenant or a prospective tenant is considered to be based on objective criteria related to one's qualities as a tenant, then that negative action is not considered to be discriminatory. So sometimes there can be a fine line as to whether or not the basis for the negative action is the objective criteria related to the person's qualities as a tenant, or whether it's based on some personal characteristic. But if for example, even the fact that a man has long hair or something is probably, even though it's not one of those listed in the group, if a landlord were to base a negative action on something like that, it very likely could be found to be a personal characteristic and not a criteria related to the qualities as a tenant. The California Supreme Court has ruled in a case that a landlord's rejection of a prospective tenant on the basis of the tenant's financial condition is not discriminatory. They had a rule that said they would not rent to tenants unless their monthly income was at least triple the monthly rent, and that was upheld as not being illegal discrimination. However, taking a negative action against a prospective tenant on the basis of what is the source of the income, as long, of course, as it's not an illegal source, would probably be found to be discriminatory. In other words, if you said, we're not going to rent to you because you have enough income, but your income comes from public assistance, or let's say it came from a trust fund or something like that and not from employment, that would probably be considered to be illegal discrimination. Okay, let's move to the situation, and by the way, I will try to talk fairly quickly and still not leave out too many details so that we can move through this and then hopefully address some of the issues you're interested in as I talk, but then I'll try to get finished fairly quickly, and it will give you a chance for questions. One of the first things that comes up when someone moves into a residential dwelling and forms a tenancy with the landlord has to do, of course, with the security deposit. That's covered in California law under the California Civil Code at 1950.5. A security deposit, regardless of what you call it, is a payment of anything or a payment of any money for the purpose of securing the tenant's obligations under the rental agreement. And it's payment for it does not include payment for current rent. So if you move into a place and they say you got to pay first, last, and security, what you're paying for the first is not security. What you're paying for last and what they call security is security. The last month's rent is security. What they call security is obviously security, but that first month payment, of course, is not security. The maximum amount a landlord can charge a tenant for security deposit, regardless of what it's called, is twice the monthly rent for unfurnished dwellings and 3 times the monthly rent for furnished dwellings. Security deposit rights are non-waivable. If the tenant agrees to give up rights to security deposit, the law would not enforce that agreement because it's not considered something a tenant can give up. Even though there's a maximum of how much the landlord can charge, double, unfurnished, triple furnished, a landlord is allowed where there is where the tenant is renting for a fixed term lease of 6 months or more. The landlord is entitled, if they agree, the landlord and tenant, to take up to 6 months in advance rent payment. That's not considered to be security deposit. It's just considered that the landlord's taking 6 months worth of rent at the beginning. So that's being paid, in other words, as current rent. That's unusual, obviously, but it's legal. All deposits are refundable. There's no such thing as a legal, non-refundable deposit. However, a landlord can charge up to $30 for actual cost of an application screening fee, such as credit check. That's not considered deposit. That's considered a cost of renting of screening the application. Tenants who are not terminated for having done something wrong or allegedly done something wrong are entitled to a pre-move-out inspection. Although I've heard different opinions about whether that goes for tenancies no matter when they began or whether that only applies to tenancies that have begun since January 1st, 2003, which is when a certain law was passed. But I personally think that it applies to any tenancy that's currently in effect. And that means that the tenant is entitled to require the landlord to come over and look at the place before the tenant moves, shortly before the tenant moves, and give a list of what the problems are that the landlord is anticipating taking money out for, and this gives the tenant a chance to correct them. Now, once the tenant has moved out, regardless of whether there was or was not, in fact, the pre-move-out inspection, the landlord is obligated to return all of the deposit within 3 weeks of the tenant vacating, or the landlord, if the landlord does not return all of that deposit, must make an itemized list and a description of where that security deposit is gone, what it has been used for, and why it was not fully returned. The typical deductions from a security deposit that are listed in the law are to pay for repairs other than ordinary wear and tear. Landlord is not entitled to take out money for ordinary wear and tear. The second listed purpose of a landlord deducting money from a security deposit is to compensate the landlord for defaults in the payment of rent. Thirdly, to clean the premises, and for tenancies that began after January 1st, 2003, this is pretty definite, The definition of cleanliness is that the tenant has left the place just as clean as it was when the tenant moved in. I always thought that should have been the definition forever. I mean, I never thought that there was any other definition than that you should just leave it as clean as you first got it. But apparently the law was passed in January 1st, 2003, and says this is the definition starting on this date. So we don't exactly know what the definition is for tenancies that started before that date. And also they can take out money for other things, like if the landlord has, tenant has failed to return personal property of the landlord or something like that. And then the law says these are just examples and they can actually take it out for anything if the landlord, when I say for anything, it doesn't mean anything of the landlord's choosing for no reason, but it means if the tenant has not kept the rental agreement and that's cost damages to the tenant that fall into some other category, the landlord obviously can compensate himself or herself from the security deposit. A landlord who, in bad faith, fails to return the security deposit to the tenant within 3 weeks can be sued by the tenant for the tenant's loss of that security deposit. And if the tenant does in fact prove the bad faith, bad faith means the landlord didn't even have a valid argument as to why he should keep the security deposit. In other words, it was obviously the landlord taking advantage. The tenant is entitled to the amount of the security deposit not returned and up to twice that amount in penalty damages. And of course, tenants that try to get their security deposits back, that landlords do not return, they usually go to small claims court to do so. You wouldn't be limited to small claims court if the damages were greater than the maximum of small claims court, but it's much more common to do it in small claims court. Okay, let's say the tenant is in the place. What are the main concerns tenants have when they live in a residential dwelling? And I actually have two that I'm going to go into, and the first one has to do with entries into the dwelling by the landlord. It's covered in Section 1954 of the California Civil Code. And just a quick word, obviously these rules and laws and rights of tenants I'm getting ready to talk about when it comes to entry by the landlord are not something anybody has to worry about if the landlord and the tenant have a certain relationship where the tenant wants the landlord to come over. If you want your landlord to come visit you, obviously you're not going to be raising these kinds of laws and these kind of rules, and the landlord doesn't have to follow this because there's no issue that comes to any kind of a competition between the landlord and tenant. So that's the issue of consent, generally speaking. But then there are also some issues of consent where the landlord and tenant don't have that relationship, but the tenant gives certain consent, not because the tenant wants the landlord to be a frequent visitor, but just wants to consent because of the specifics of the entry. Well, a tenant has a right to freedom from unwarranted entries. A landlord who does not have a court order, because sometimes they have court orders that allow them to enter without regard to these laws. But a landlord without a court order, in order to enter a dwelling that the tenant is residing in and has not abandoned, must have a proper purpose before entering. The purposes listed in the law are to remedy problems in an emergency, to make repairs or supply services, to show the place to prospective purchasers or repair people or mortgagees or possibly new tenants that are coming down the road in the future. So those are proper purposes. An entry must be during normal business hours. Of course, a tenant could consent to allowing an entry at not a normal business hour, and some tenants might say, I prefer it not to be normal business hours. Like, I don't want you here between 9 and 5. I'd rather you come over at 8 o'clock tonight when I'm home. But the law requires normal business hours unless the tenant consents otherwise. There must be notice, generally. The notice must include the date, the approximate time of the entry and the purpose. The notice must be written, and it must be sufficiently given in advance. 24 hours advance notice delivered to the tenant is presumed to be sufficient advance notice, unless there are circumstances to the contrary that would allow a shorter time or would require a longer time. But it's presumed that 24 hours is the reasonable amount. Now that's if the notice is delivered. If it's mailed, the presumed reasonable amount of time is 6 days in advance. That's one 24-hour period plus 5. The law has these repeated things in it about mailing where they say if you do it by mailing, you have to add 5 days. Now that's not true of every written notice in the law, but it's true of a lot of them. A landlord can give oral notice to a tenant, and it's considered proper if the reason for the entry is because the place is for sale, and the reason for entry is that prospective buyers are coming. A landlord can use oral notice, but oral notice only if within 120 days previously the landlord has given a written notice that says this place is for sale, and therefore I'm going to be having various people come and look at the place. So I don't have to give you a written notice every time, but I'll give you an oral notice each time. And it seems that you have to renew the written notice every 120 days in order to justify those later oral notices. Notice is not required for emergency entries or if the tenant consents, if the tenant is present and consents at the time of the entry. And regardless of whether or not the landlord's meeting all these technical rules, still the landlord is not supposed to use entry to harass the tenant. And also, landlord is not allowed to abuse this privilege of entry. If a landlord does significantly and intentionally violate these entry laws, and the purpose of doing it is to try to force the tenant out, the landlord obviously can be sued for it. Just on the basis that if you violate the law, people have a right to sue you for their damages. But there's a particular code section that says the tenant has a right to recover penalty damages of up to $2,000 per incident for that violation of the entry laws. Okay, the second issue, and I'll try to move fast here, is second thing that tenants and landlords frequently have issues about when a tenant's living somewhere, of course, is the issue of repairs and maintenance and keeping the place in good condition. A landlord has a duty under state and local laws to make a residential housing habitable or what they call tenantable. That doesn't mean pleasing aesthetically, but meeting minimum standards of structural integrity, etc. California Civil Code lists weather protection and waterproofing, good electrical, good structural integrity, stairs and railings and everything being in good repair, sanitation free from vermin, etc. There's also so the landlord has a responsibility to the tenants to keep the place habitable and tenantable. If the landlord does not meet the minimum requirements of habitability and tenantability, then the landlord is violating the law. Both the civil code that I mentioned, there's also a health and safety code that has been incorporated by many local by many counties. For example, Nevada County incorporates the state health and safety code and makes those standards the local building and housing codes. And if a landlord significantly violates the local building and housing codes to an extent that endangers the life, the limb, the health and safety of the tenant, then the landlord is not meeting the tenantability or habitability standards. there's a particular section in the law that says that if the landlord has been cited by a housing building inspector, something like that, maybe health inspector, and for 35 days after having been cited has failed to remedy the problem that the landlord was cited for, it's illegal then for the landlord to raise the rent on the tenant, to demand rent, to collect rent, or to give a 3-day notice to pay rent or get out. And if a landlord takes those actions, typical things that a landlord might do without violating the law, but a landlord who's under this citation and is not remedying it, then the tenant can sue that landlord for actual damages and special damages, the law calls it, of up to $100 to $5,000 for each such violation. Now, that's in, by the way, California Civil Code section 1942.4. But regardless of whether there's a citation against the landlord or whether the landlord's failing to do what the building inspectors or housing inspectors want, just in general, a tenant has a legal right to take a landlord to court if the landlord is what they call breaching the implied warranty of habitability. Now, just because the tenant has a right to take a landlord to court, it's not always a good idea. Obviously, first of all, the tenant could lose. The tenant could take the landlord to court and lose the case. Or the landlord could take the tenant could take the landlord to court, and even if the landlord wins the case, the tenant wins the case, the friction that that can cause if the tenant is going to try to stay in the place and stay in good relations, of course, can be so overwhelming. The tenant might have decided that that it's a victory that's just almost as bad as defeat. So obviously it's something the tenant has to be careful about. Now, 2 other quick remedies that a tenant might take who's having trouble getting the landlord to fix and keep a place up to tenantability and habitability standards. The first is called that I'm going to mention is called repair and deduct. If there's a dilapidation in the premises which affects habitability that the landlord ought to repair but has not, even though the tenant has given notice and sufficient amount of time has passed and the landlord still hasn't fixed this, the tenant is allowed to fix it herself and deduct the cost from the rent and then just pay the rent minus the deduction. The tenant is allowed to do this per incident or per time for no more than 1 month's rent, and is allowed to do it only twice in a 12-month period. I guess if the tenant did it twice in a row, that would be almost the same as deducting 2 months' rent. But anyway, no more than 2 months' rent in a 12-month period, and no more than 1 month each time it is being done. And then the other thing a tenant can do who's trying to get the landlord to maintain the premises properly, and this is something that is definitely a very severe action on the part of the tenant, is to withhold the rent entirely or withhold a part of it. Not take the money and go repair it and withhold it in that sense or deduct it in that sense, but just don't pay it, whether you use it, whatever you use it for. And that's what they call rent withholding. Is it legal to withhold rent? Yes, it is legal to withhold rent in the proper circumstances. Just like it's legal if you think somebody is getting ready to kill you, it's legal to kill that person first in the proper circumstances. But if you make a mistake, then the repercussions can be really bad, obviously. So the same goes for rent withholding, not on the same scale, of course. But if you believe that you have the proper circumstances to withhold, but the landlord does not believe you have the proper circumstances to withhold, then you're both going to be in a position where you believe the law is on your side. And whether the law really was on your side and you had a right to withhold you never know until it comes to court, and if it turns out you're wrong, you didn't really have the right to withhold because the circumstances didn't warrant it, then the repercussions could be pretty bad. I mean, not like the ones regarding people defending themselves with violence or murder or anything like that, or self-defense. Okay, now, one other subject I'm going to talk about here is notices that landlords have to give to tenants. And those notices sometimes have to do with terminating tenancies. So I'm going to return to this breach of warranty of habitability just for a second, or for a few minutes, or for a minute or two, when we get to notices of termination of tenancy. Generally speaking, if the tenant has a tenancy for a fixed period of time, for example, a 1-year lease, the landlord can't give you a 30-day notice in the middle of the lease, I'm changing your terms, or I'm terminating you without any reason, but I just need to terminate you, because you have a fixed term lease. But if you have a month-to-month tenancy where you're only renting 1 month at a time, so to speak, then the landlord can change the terms of your tenancy, including terminating you from your tenancy, on a 30-day written notice. A written notice is required, and it has to be at least 30 days, except for some exceptions where a shorter notice is allowed, but we don't really have time to go into them now. A rent increase, by the way, that raises the rent more than 10% higher than it has been at its lowest point in the previous 12 months requires a 60-day notice. So if you rent somewhere for $1,000 a month and they're raising the rent by $150, they should give you 60-day notice, not 30. The landlord does not need a ground to terminate a month-to-month tenant. There's no grounds required unless you're in a place where they have local eviction and rent control laws. But a place like Nevada County, if you're a month-to-month tenant, you can be evicted on 30 days' notice, or the landlord has a right to terminate you on 30 days' notice. If, however, a tenant gets a 30-day notice to vacate and does not vacate, then the only thing the landlord can do to force the tenant to vacate for not having done so is to take the tenant to court. It's illegal for the landlord to use force, intimidation, lockout, cutting off of utilities, or anything like that to enforce that notice to vacate. And the landlord cannot use law enforcement to do it. Law enforcement will not do it without a court order. You can't call up the police and say the tenant didn't leave, come and remove the tenant. There is an exception where a landlord and a tenant share a dwelling, where a landlord shares a dwelling with only one tenant, and the landlord has access to all of the unit and total control of the unit, then that type of person can be removed by police without the landlord having gone to court first. Now, I did mention quickly that landlords don't have to have a reason to evict a tenant, but just because landlords don't have to have a reason to evict a tenant who has a month-to-month, it doesn't mean the landlord can do it if there is, in fact, a bad reason. In other words, the landlord can do it for a good reason or no reason. The landlord can't do it for a bad reason. What's the bad reason? 2, discrimination or retaliation. You can't, just because the landlord can evict a tenant for no reason doesn't mean the landlord can evict a tenant because the landlord disagrees with the tenant's religion, for example. Okay, so let's say a landlord gives a notice of termination of tenancy. Tenant doesn't leave. The landlord does what the landlord is supposed to do, go to court. The landlord files a court case. It's called unlawful detainer, and then the landlord has to have those court papers served on the tenant. If the tenant doesn't respond to the papers, the tenant will probably be evicted by default without ever getting to tell his side of the story, so to speak. But if the tenant does respond to the unlawful detainer papers, the court will set up a trial in which the court will determine whether the landlord is right. The landlord has done the legal requirements to do the eviction, which is, of course, giving the notice, or if cause is required. Now, I didn't mention this before, but for example, let's say it was a termination of a tenant who was in the middle of a lease. Well, to evict that tenant, the landlord would have to have a cause like non-payment of rent or breach of the rental agreement by the tenant or something. So obviously cause is required. Cause is also required if the landlord wants to evict the tenant not on a 30-day notice. I'm talking about now even a month-to-month tenant. But a landlord doesn't want to give 30 days notice, wants to give 3 days. Then there has to be cause. In other words, 3-day notice to pay the rent or get out. 3 days notice to get rid of the pet that's violating the rental agreement or get out. So anyway, so let's say the landlord has brought the case to court. The tenant responds. The court will set up a trial in which it is determined whether the landlord either has cause to evict if cause is required, or if cause is not required, the court still has to determine, did the landlord in fact give the notice? Did the tenant receive the notice? Did the time expire? Okay, now, if a tenant receives a notice, the tenant has a right not to move, in a sense. The tenant can say, I'm not moving, I'm going to defend myself in court. But there are drawbacks to defending yourself in court. I'm not suggesting someone doesn't do it, but because it's up to the individual. But when you defend yourself in court and the landlord has to file that court case, then the fact of the court case can show on credit records and tenancy records, and also sometimes a tenant can be subjected to owing the court costs and attorney's fees for the landlord. So a tenant who does not move upon receiving a notice runs certain risks in not moving. But if the tenant feels that there is a legal reason for not leaving the premises, obviously that tenant may want to take those risks and defend herself. I guess this gives me just maybe enough time to say here that if a tenant has in fact done rent withholding or repairing and deducting, well, I'll talk just about the rent withholding. Let's say the tenant did that rent withholding and the landlord served the 3-day notice to pay the rent or get out. Tenant still didn't pay. The landlord files the unlawful detainer. The tenant defends. The case comes to court, and the tenant can't convince the court that there were proper circumstances to do rent withholding. The judge or the jury decides the problems were not bad enough to justify rent withholding. What's going to happen to the tenant? Tenant's going to be found to be illegally keeping the premises when the tenant didn't pay the rent that was due, and the tenant most likely is going to get evicted. Let's say the tenant convinces the court that the premises were bad enough to rent withhold. The court is then going to have to take one further step. How bad were the premises? Bad enough to withhold, but bad enough to wipe out all the rent? Probably not. Maybe bad enough to wipe out, let's say, 25% of the rent. Then that means the tenant has to pay to the landlord the other 75% that was withheld. And if the tenant doesn't do it, the tenant loses it again. The only way the tenant can win is prove to the court there should be a reduction. Secondly, pay the reduced amount within a few days. Otherwise, the tenant loses. A tenant who loses is most likely going to be evicted. The sheriff does the evictions, and it could happen within 6 or 7 days of losing. The sheriff has to post a 5-day notice on the door that we're coming out to evict you, and it takes the sheriff a day or so after getting the paperwork. But even a tenant that loses a case can sometimes prove that this is should not result in a forfeiture of tenancy. Maybe the landlord didn't put the right words in the eviction notice or something, saying that the tenancy will be forfeited. Or sometimes a judge, even when a tenant loses, will say, if you'll throw yourself at the mercy of the court, that old phrase, and say, I lost the case, I'm in the wrong, I'll do everything I was supposed to do earlier if it was an eviction for having done the wrong thing, like not paying the rent, if you'll just reinstate my tenancy, and sometimes the court can do that. A tenant does have a right to have access to the court to at least make that request of the judge. But the more likely result of the court finding in favor of the landlord is that the tenant will get evicted within a few days of the judgment. But the landlord still has a duty to keep keep the belongings for a couple of weeks thereafter. Now, of course, tenants and landlords, regardless of who wins or loses, regardless of who loses, whether it's landlord or tenant, do have rights of appeal and rights to request that the court grant a new trial and all those things. But those are long shots. It's very rare that an appeals court will overturn the verdict of a lower court. Although it does sometimes happen. But usually, if the tenant loses, that means the tenant has to leave. That's all that I have in this initial presentation. So now how long should I go, Helen? Should I stop exactly at 1 o'clock? Or? Oh, okay. Well, you don't have to tell me. Just tell me to leave when the time... So I'll try to take questions in the order.
And we've had leakage in our basement since the previous winter. Landlords came over and put some caulking and didn't work. We had several leakages throughout the winter.
You know, people frequently say, maybe I should run and report this. I think it's sometimes you want. I think the decision of whether to report should usually be made on the basis of, are you reporting it because you really want that inspector to be on your side, so to speak? When people report it just to make a record or just to if you feel that by reporting it you increase the chances of being fixed, that's certainly a very legitimate reason. Well, I'll try to. First of all, $200 raise out of a rent of about $1,200 sounds like about a 16% increase. Did she give you 60 days notice or 30? Oh, she did. Okay. It sounds as if the conditions are severe enough, then even though I don't know if you actually reside in the basement, but if the basement is causing the mold to affect the overall living space, okay, it sounds like she's not keeping the place tenantable. And that's because California Civil Code Section 1941.1 specifically mentions waterproofing and weather protection as absolute requirements for making a premises tenantable. So if there's leakages that are causing mold, it doesn't seem tenantable. Now, again, I'm not necessarily suggesting you withhold your rent, because if you withhold your rent and a court were to determine, if she tries to evict you, that they don't think it was bad enough to withhold, then they don't just say, okay, it's not bad enough to withhold, you better pay that rent or we're going to make you leave. They almost always say, you didn't pay the rent, you took your chances, you lost, you're going to get evicted. So I wouldn't. Okay. It is illegal to increase the rent in retaliation for you having complained and asserted your rights. Okay, that's not. I'm sorry it took so long to get to it. 1942.5 of the Civil Code is the retaliatory eviction section, but it also says that landlords, not only can they not evict you in retaliation for asserting your rights, but they can't raise your rent. Now, what that means is that you could theoretically keep paying the old rent, okay? But if she goes to court, if she takes you to court for non-payment of the full rent, and you defend yourself on the grounds that she had no legal right to raise the rent, and therefore your payment of the old rent was justified, if the court disagrees with you and says, we don't find it to be retaliatory, then that means you're in default of the full rent. You didn't pay the full rent. You'll be evicted. Okay? Remember, people can do all these. They can do these things where the law says they have a right to do things. But if you do them, and then the landlord tries to evict you, you see, she's not going to go into court and say, I'm evicting you to retaliate. She's going to go to court and say, I'm evicting you because you didn't pay the full rent. The judge isn't going to assume that she's retaliating. The judge may feel that her rent increase was justified. If the court finds that your rent increase was justified, then you'll be in default of the payment of rent, part of the payment of rent, and you'll be evicted for non-payment of rent. On the other hand, if you convince the court that the rent increase was illegal because it was retaliatory, and as long as you paid the rent before the amount that it was, before the increase, then you won't be evicted. But see, it's a risky strategy. Maybe it would be better to pay the full rent, then write her a letter saying, I demand that you refund the rent because this was obviously a retaliatory increase. And then if she won't give it back to you, take her to small claims court. And then if you lose, all you have is further bad relations between you and the landlord, but at least you don't get evicted. Okay, I should move to the next person, but it's not tenantable, not habitable. You don't have to, but if you did call the health inspector and the health inspector came and cited it, it seems like it would, one, just give you stronger evidence, and two, it would activate that section that says it's illegal for the landlord to demand rent, collect rent, raise rent, or, yeah.
Enter your premises using their key, even though you...
Time that's pretty much different from when the notice was?
Yes, substantially different time. You leave the house and do something else, and the landlord comes and says, enter your...
Okay, do you have a month-to-month tenancy at this point, or a lease? Lease for a period of time. What sort of losses do you envision yourself suffering from the deposit the landlord holds is called deposit and not called last month's rent? Okay. Because if they call it last month's rent, even though it has the same ramifications in a lot of ways, if it's last month's rent, you can actually apply it to the last month. You could first request that the landlord just apply the deposit to the last month, and if you requested and the landlord went along with it, it would be okay. There is a strategy that's not totally going along with the rental agreement. It's a violation of the rental agreement, but a tenant can sometimes do it and get away with it. That is, the tenant can just, even though it's called security deposit, and even if the landlord won't agree with you, you can just notify the landlord, the money that you're holding as deposit, I want you to apply to my rent, and you only, of course, to the amount that it covers. You obviously want the landlord to return any amount that's left over. Now, if the landlord just won't allow that, if the landlord then the landlord could give you a 3-day notice that you're in default in the payment of rent, and then you find yourself in the middle of having to defend yourself. In this situation, though, you have a lot of leverage with the landlord, you would think, because the landlord is failing to fix a problem, right? But don't you think that would cause the landlord possibly to realize that it would be better off just to let you move and apply the security deposit to the rent, or not? You don't think that's likely? Well, again, I can't, obviously in order to keep a landlord from evicting you or trying to evict you before you're ready, you normally have to keep your rent current. So a tenant who's having trouble keeping rent current and also moving somewhere new because they got so much deposit tied up, it is a problem. I understand that it is. I think that you could consider taking the landlord to small claims court. Be a simplest way for you to try to get compensation for your harm without getting involved in a real complicated court case that unless you feel you have huge damages for your daughter and everything. And I think maybe the threat of the small claims court action gives you some leverage that they're better off, if they want to avoid the small claims court action, just to let you apply your security deposit, and that way don't pay any extra rent. And by the way, if there's any security deposit greater than the amount of rent that would be owed for whatever period you do stay, you still, of course, want them to return it. And then that way, by not having to pay some more rent, you're able to save up a little money to pay the deposit in the new place. A tenant has a right to get out of a tenancy without being found to be in breach of the rental agreement, where the conditions are so severe that the tenant is being constructively evicted. So the abandonment method just means that instead of staying there trying to get the place fixed, you can just move out. See, you can just move out anyway because you don't have a lease. That's really to deal with people who have leases who think, I'm in a horrible place, they won't fix it, and I'm stuck because my lease requires me to stay. I haven't, but you're not required to stay if it's that bad. I guess I should take the Truckee question. Sorry, I know there are a lot of questions over here. For occupancy and tenantable and habitable, even though the law puts the burden on the landlord, not on the tenant, it is true that if the landlord and tenant are actually making a voluntary, non-coerced agreement, that the tenant will be responsible for some repairs, and that's in return for the tenant not having to pay as much rent. For example, that would be a valid reason why a tenant and landlord might voluntarily enter into an agreement like that. Such an agreement would be legal. And of course, where a tenant has agreed to make certain repairs, even though those would be repairs the landlord would ordinarily be obligated to do himself or herself, that agreement could shift it to the tenant, to where the tenant cannot then claim that the landlord is deficient in her obligations, because after all the tenant agreed to do it. In other words, if a tenant agrees to fix a certain problem that the place has, and that's not a coerced agreement where the landlord is pressuring the tenant to agree to do so, but the tenant gets a benefit for making that agreement, and then the tenant later says, oh, landlord, you didn't fix that, I'm going to repair and deduct. The tenant would obviously be wrong because the tenant agreed to do it. Again, I don't know much about mobile home tenancies, and for people who are here, I did say that we could maybe go into the library and look at some references, but I don't feel comfortable answering it. The law says that you can't refuse to rent to families on the basis that they are children. Okay, you can't. Right. If you have a rental agreement with a one-person maximum, and we're not talking about the person having a child, that might create problems. Giving birth to a child, but just had somebody move in, and that violates the rental agreement, then probably that violation of the rental agreement would be grounds for termination. By the way, is the rental agreement going to be a rental agreement for a period of time or a month-to-month? Well, with a month-to-month tenancy, you don't have to have a grounds to terminate a month-to-month tenancy. Okay. You can terminate it for no grounds or for a good ground, but you can't terminate it for a bad ground. You can't terminate it to retaliate or to discriminate. Now, even though it says one person, and let's say you rented it to a woman, and then this woman a year later gave birth to a child, and even though you had a one-person limit in your rental agreement, I think that, remember, this person didn't just go out and bring in a roommate. This person gave birth to a child. I really think it'd still present a definite problem as to whether it would be legal to evict for having violated the one-person agreement when it wasn't a situation of bringing in a new person from the outside. It was giving birth.
First of all, if you do in fact have the legal right to force the tenant out, because the nuisance is what really describes the situation, as opposed to disability being what describes the situation, then I don't think any action you're taking is likely to be risky. But if in fact it's the disability or the medical condition that really is the best way to describe this issue, then you have to be careful that you're not pushing someone out without the usual notice. Landlords are supposed to actually use the normal notice procedure to terminate their tenants. So when they use methods of termination that are not the true notice, that's almost worse than giving the right notice.
Well, the full notice is okay, and the person downstairs would certainly substantiate, because he's the one who's being bothered by the noise. So, well, I guess it just...
I do think in this case, in order for the tenant to be able to claim that this is a discriminatory eviction, the tenant would really have to have a strong link between a recognized medical condition or disability being the cause of the nuisance. But I wish I had a better answer, but this one sounds really sticky. Like, there are two competing legal interests involved, and how a court would deal with it is really hard to predict. Maybe I should take a question or two over here. I know that you've been okay. You in the light green next.
Mine is just real short. For the section 1954 for entry to
Yeah.
a building, is that the same for commercial as it is for residential?
I believe that 1954 is for residential, and I believe commercial is just not governed by that. I'll tell you what, though, I might like to look at 1954 or look at, I don't know if you have time or not, but I don't believe there's anything right in 1954, but there must be some reference to it somewhere that would say, I can't remember for certain whether 1954 applies to commercial as well. Do you know, John?
I do not know.
I don't think commercial tenants have quite the degree of protection
Where when you move into an apartment,
when the tenant moves in.
yes.
Yeah. That
Require the landlord to do it? No, I don't believe so. The landlord has a duty to make the premises tenantable and habitable. And the laws on tenantableness and habitableness are written in sections of the code that I can give you. But it's not per se that they have to shampoo or paint. But if the carpet were so bad as to be unsanitary, then they're not making it habitable. So in that sense, if shampooing is what's necessary to make it habitable, then they do have to shampoo it. Not because the law per se says they have to shampoo it, because it's not habitable if they don't. The Health and Safety Code 17920.3 gives a long list of things that have to be done, or else the dwelling is considered substandard. It's a real long list. Some of them are general, like must be clean, must be sanitary. Some of them are real specific, very specific things about what they have to do. So if the carpet is so dirty as to be unsanitary, I'd say they have. Now, the same goes for paint. If you have a lot of paint peeling and chipping and falling, even if it's not lead paint, if it's lead paint, that's even worse, but if it's not lead paint, but it's still likely to fall in food, and it's likely to fall on people's beds and things, then they have to remedy that problem. But there's no law that says every time the landlord changes
into the equation.
It's more the 18-day notice that you have 18 days to come remove your personal property.
Okay.
Well, because it's a mobile home, it is making it complicated, because a mobile home can be both real estate, if somebody's occupying it, or in this case, it's been reduced to a piece of personal property. So it is kind of a complicated issue. It presents a more complicated issue, but it sounds like we're going down the path here that this is personal property, and so we're not looking at the rules on removing a tenant from a dwelling anymore. We're talking about removing a piece of personal property from your space.
Right. Okay.
Is the mobile home on the secured or unsecured tax rolls?
She only, I'm assuming, pays, personal property tax versus, she doesn't pay, she doesn't pay actual property tax. I'm assuming it's the way it used to be when you used to pay to the DMV for a mobile home.
Okay, that's what you need to find out. Don't assume.
Yeah.
You need to find out, because she could receive an unsecured tax bill, or she could be paying DMV.
Okay. Okay.
Because the tax assessor does tax mobile homes, and sometimes they're on the unsecured tax roll.
Okay.
Any questions here in the Nevada South?
Thank you.
You're welcome.
You're welcome. Any questions here in the Nevada City courtroom?
Thank you.
Okay, we'll stop.
Thank you, Robert. Thanks a lot. That was really
Thank you for helping me.
Thank you.
For instance, you're talking.
Easy K.